Imagine an asset so valuable, companies fight for years through the courts over not gold, not land, but a phone number, specifically 1-800-BATHTUB. Today, we're diving deep into this really fascinating Michigan Court of Appeals case, 1-800-BATHTUB LLC versus ReBath LLC. It's a legal saga that shows us how contracts, claims of digital theft, and some incredibly subtle legal distinctions can spiral into a huge multi-million-dollar fight. Our mission here really is to unpack this complex journey for you. We'll explore how something that seems so simple, a toll-free number, can become the absolute center of a legal storm. And doing that reveals some surprising things about contract law and the very fine lines between different kinds of legal claims. We're talking about concepts that might sound abstract, but in this case, understanding the subtle differences literally meant the difference between like an $80,000 award and a payout over $1 million. That's the real stake here for businesses.
Yeah, this case is a fantastic example. It really shows how modern assets, especially these intangible ones like a vanity phone number, they constantly challenge our, let's say, traditional legal frameworks. It really highlights how important it is to understand not just what's written down in a contract, but also, the broader legal duties. Do they exist outside the contract? Do they not? And how do courts tell the difference?
Right. So we'll look at the key players. 1-800-BATHTUB, LLC, they own the number, and ReBath LLC, who, well, they used it for years. And we'll zero in on that core question. When does breaking a promise in a contract, when does that cross the line into something more, something like actual theft? And what really dictates that difference in the legal outcome? Okay, let's unpack this. Okay, let's start at the beginning. You might think, a toll-free number is just digits, right? But in business, a vanity number like 1-800-BATHTUB, that's 1-800-228-4882. That is a potent marketing tool. Super easy for customers to remember, a real differentiator. It's kind of wild to think a phone number can be this valuable. I remember trying to get a custom email back in the day and realizing all the good ones were gone. It's like digital real estate.
You've hit a crucial point there. The case tells us that Edward Hirsch, who was the sole member of 1-800-BATHTUB LLC, he actually acquired this number way back in February 2001, paid $10,000 for it from another company, Crescent Supply. And interestingly, he also got other vanity numbers like 1-800-EyeCare, 1-800-ASPHALT. It suggests, a business model built around these valuable, intangible things, the value placed on something you can't physically touch. It's fascinating.
Okay, so fast forward to July 2002. 1-800-BATHTUB LLC and ReBath LLC, they enter into this marketing services agreement, the MSA. Sounds pretty standard, right? At first glance, what were the key terms?
Well, under this MSA, Bathtub leased the number to ReBath for its exclusive use. But it wasn't just a simple lease, actually. Bathtub also provided a whole suite of services, client billing, telephone switching, marketing support. In return, ReBath paid a monthly fee. And by 2013, that fee had grown quite a bit. It was an $80,000 annual fee. Now, crucially, the MSA specifically said Bathtub kept ownership of the number, and ReBath agreed it had no right or authority to contact the service provider or take any action aimed at transferring the number. It also had an arbitration clause, to handle disputes privately, and a limitation of remedies clause, which is meant to cap potential damages.
Okay, $80,000 a year, that's a serious commitment.
Yeah.
But this quiet arrangement, it took a really dramatic turn, a decade later, when ReBath started questioning the whole deal. Yeah. By March 2017, ReBath decided or developed this belief that the MSA was actually illegal. They claimed it was hoarding or brokering a toll-free number, which violated federal regulations. What exactly do those terms mean here? And why did ReBath suddenly think this applied after all that time?
Right, that's the key question. The regulation involved is 47 CFR 52.107. Hoarding is basically when a subscriber gets more numbers than they actually intend to use, especially if they get them from a responsible organization that's the official entity managing the number records. And brokering is, selling a toll-free number for a fee. Both are prohibited by the FCC. The idea is to ensure fair use and allocation of what's seen as a scarce public resource. So ReBath's argument was essentially, look, Bathtub is acting like an illegal broker here by charging us this fee just for the number itself.
Okay, so who you get the number from and how you structure the deal seems really critical. Is it just the number, or is it services plus the number?
Absolutely. That distinction became central later on. That's precisely what the arbitrator had to figure out. But ReBath, they didn't wait for a judge or arbitrator to decide. They took action, decisive action.
So ReBath basically just grabbed the number and locked it down. From Bathtub's side, that must have felt like theft. Was that a typical move in these kinds of disputes, or was it unusually aggressive?
Oh, it was certainly aggressive. It escalated things dramatically. In April 2017, ReBath contacted Windstream. They were the designated responsible organization for this number, and ReBath claimed they were the actual subscriber. They asked Windstream to transfer the number to their own provider, Patriot. Windstream did it. And then ReBath put a digital lock on the number. That meant it couldn't be easily transferred again without their say-so. They even went and trademarked the number. And not surprisingly, they stopped paying under the MSA in January 2018.
Wow.
Yeah, so this really raises the core question. Was this just a breach of contract, failing to follow the agreement, or was it something more, something like conversion, the actual theft of property?
And that something more is exactly what 1-800-Bathtub pursued. September 2018, they start arbitration, initially just for breach of contract. But then they added a claim for conversion, which, legally speaking, is the wrongful taking and keeping of someone else's property. And ReBath fired back, didn't they? They counterclaimed, saying the MSA was totally void because of this illegal brokering idea and they wanted all their past payments back. So this was quickly turning into a really high-stakes million-dollar gamble for both sides.
Right.
With such a major disagreement and ReBath taking that kind of unilateral action, it was bound to escalate. The next stop was a formal arbitration hearing, that private legal process. So they had a 3-day hearing, and in March 2020, the arbitrator issued a decision, an award. What did they find about ReBath's claim? This idea of illegal brokering or hoarding?
Well, the arbitrator largely sided with 1-800-Bathtub on the key points. They concluded that Bathtub had not engaged in illegal hoarding or brokering. The reasoning was pretty specific. First, Edward Hirsch got the number from another subscriber, Crescent Supply, not directly from a responsible organization. That's a crucial distinction under the FCC rules.
Ah, okay. So not from the official gatekeeper.
Exactly. The rules against hoarding are really aimed at companies getting numbers from those official sources and then just, sitting on them without using them. Acquiring from another user, especially when bundled with services, that's different. And second, the arbitrator found Hirsch intended to lease it and provide services, not just sell the number outright. These bundled services and shared use agreements were actually seen as a favored use of toll-free numbers. So the MSA, perfectly valid according to the arbitrator.
Okay, so the contract was valid, and ReBath clearly breached it by, taking the number and stopping payments. What about the conversion claim, the alleged theft part? Did the arbitrator buy that too?
Yes, they did. The arbitrator found that ReBath's actions, porting the number away, putting that digital lock on it, absolutely constituted illegal conversion. They saw it as an intentional act. ReBath knew, or should have known, that 1-800-Bathtub was the real subscriber, the owner. They went even further, finding ReBath liable for willful, wanton, and reckless misconduct. And because of that finding, they said the contract's limitation of remedies, clause the part, meant to cap damages, just didn't apply here.
Okay, and what about this economic loss doctrine that ReBath raised? They argued that conversion claim entirely, right? Did the arbitrator agree with that?
Nope, the arbitrator rejected that argument flat out. They found the conversion claim was separate and distinct from the breach of contract claim. So for damages, this is where it gets really big. They awarded $80,000 for the breach of contract, basically, the unpaid annual fee. But for the conversion, they valued the number itself at $400,000. And then, citing a statute allowing extra damages for intentional conversion, they trebled that amount to $1,200,000.
Wow, trebled.
Yep. So add the $80K contract damages, the total award was $1,280,000, plus attorney fees for Bathtub, since they were the most prevailing party.
That is a huge swing, from $80,000 to over $1 million. But, okay, the story doesn't end there. The case then went to the circuit court, which actually overturned part of the arbitrator's decision. What happened?
That's right. The circuit court looked at the arbitrator's award. They agreed, yes, the MSA was valid, and yes, ReBath breached it. They deferred to the arbitrator's factual findings there, which is pretty standard in reviewing arbitration. However, the circuit court vacated the huge conversion award. They decided the arbitrator should have applied the economic loss doctrine after all. And applying that doctrine barred the conversion claim. The court's reasoning was that neither Bathtub nor the arbitrator had really identified a legal duty for the conversion claim that was truly separate and distinct from the duties already laid out in the contract. They also denied the attorney fees to Bathtub. So this really brought that crucial question to the forefront. What are the boundaries between breaking a contract and committing a separate wrong, a tort-like conversion?
Okay, now we get to the Michigan Court of Appeals, the real heart of our deep dive today. So the circuit court stepped in, said the arbitrator got it wrong on conversion, applied this economic loss doctrine, but the arbitrator had specifically said the claim was separate and distinct. It's getting legally complex, but it's where that $1 million difference hung in the balance.
Yeah.
What was the final word from the Court of Appeals on this?
Absolutely. And the Court of Appeals started by reminding everyone just how limited judges usually are when reviewing arbitration awards. You generally can't just second guess an arbitrator's facts or how they read the contract unless there's a really clear, obvious error of law. So first, on ReBath's attempt to challenge the MSA's validity again, the Court of Appeals basically said, nope. They upheld the arbitrator's finding that it was a valid lease and service agreement, not illegal brokering or hoarding. They said ReBath was just trying to re-argue the facts, which they couldn't do.
Okay, so the MSA itself was solid. But what about the big issue, the conversion claim? Did the Court of Appeals agree with the Circuit Court that the economic loss doctrine should have blocked it?
This is where it gets really interesting. The Court of Appeals actually disagreed with the Circuit Court about why the conversion claim failed. They didn't think the economic loss doctrine was the right reason. They clarified that in Michigan, the economic loss doctrine primarily applies to contracts for the sale of goods, not generally for services. And the arbitrator had already determined the MSA was a service contract.
Ah, okay. So that goods versus services distinction was key again.
Exactly. Think of it like this. If you buy a faulty product, a good, your main remedy is usually based on the contract or warranty. But if you hire someone to perform a service, and they mess up badly or intentionally cause harm beyond just not doing the service right, other legal duties might come into play. Plus, they noted Michigan law already has exceptions to the economic loss rule for some intentional torts, like fraud. And they mentioned an emerging trend elsewhere to maybe include conversion as an exception too. So, bottom line, the arbitrator was actually right not to apply the economic loss doctrine, even if his stated reasoning was maybe a bit different.
Okay, wait. So the arbitrator was right that the economic loss doctrine didn't apply. But the Circuit Court still threw out the conversion claim, and the Court of Appeals agreed with throwing it out. How does that work? It seems contradictory.
It does sound confusing at first, but here's the twist. The Court of Appeals said, yes, the economic loss doctrine doesn't bar the claim here, but the conversion claim is still barred, just for a different reason. They affirmed the result of the Circuit Court, no conversion claim allowed, but base it on the separate and distinct doctrine.
All right, let's unpack that. What is this separate and distinct doctrine, and how is it different from the economic loss doctrine if they both ended up kicking out the conversion claim in this case?
Well, they're closely related, but the separate and distinct doctrine is older, rooted in common law. It focuses specifically on whether the tort claim, the conversion claim here, alleges a violation of a legal duty that exists independently of the duties created by the contract itself. It often distinguishes between misfeasance, that's active misconduct, doing something wrong, which can support a tort claim alongside a contract claim, and nonfeasance, which is simply failing to do what the contract promised, which usually only sounds in contract law.
Okay, that's a subtle distinction. Misfeasance versus nonfeasance, active wrong versus just not doing something. Can you give us that car analogy again? How did the court apply it here?
Right. So nonfeasance is failing to deliver the car as promised, pure contract breach. Misfeasance is crashing the car into your garage while delivering it. The crash is a separate wrong, potentially a tort, beyond just failing the delivery contract. Here, the Court of Appeals looked at ReBath taking the number and said, essentially, was that more like just failing to follow the contract, or was it like crashing the car?
And their conclusion?
They concluded there was no duty separate and distinct from the contractual obligation. Why? Because ReBath's ability to even access and transfer the number, their opportunity to convert it, only arose because of the contractual relationship they had with Bathtub through the MSA. The duty not to take the number was, in essence, the very same duty that was already spelled out in the contract, the promise not to contact the provider or transfer the number. Since the duty under the conversion law was effectively the same thing as the duty under the contract in this specific context, a separate tort claim couldn't stand.
I think I get it. So it wasn't like ReBath violated some general public duty not to steal phone numbers that applies to everyone. Their specific duty not to mess with this number came directly from the promises they made in the contract.
That's a great way to put it. The contract itself defined the specific wrong. It wasn't a wrong independent of that agreement.
And didn't one of the judges write separately to make this point even more simply?
Yes, exactly. Justice Cameron wrote a concurring opinion. He basically said, look, let's cut to the chase. The MSA explicitly banned ReBath from contacting the carrier or transferring the number. When ReBath did exactly those things, it unquestionably violated the contract. Full stop. Because the contract specifically addressed and prohibited the very actions that formed the basis of the conversion claim, it was a direct breach of contract. Therefore, a separate tort claim for the same conduct was barred. It really drives home how important clear, specific language in your contract can be.
Okay, so after all that legal back and forth, what did this finally mean for the money, the damages, the fees? This is where that $1 million difference really landed, right?
Precisely. The $80,000 awarded for the breach of contract, that stood. ReBath still had to pay that. But the massive $1.2 million conversion award, vacated, gone.
Ron,
So ReBath avoided, basically a 12-fold increase in what they owed. And as for attorney fees, the Court of Appeals agreed with the Circuit Court, no fees for Bathtub. They hadn't properly asked for them based on the contract breach claim earlier in the process. And without the conversion win, they weren't the substantially prevailing party anymore, which is usually needed for a court to even consider awarding fees. So a huge win for ReBath on the financial front, even though they were still found to have breached the contract.
So there you have it, a multi-year battle over a phone number. It took us through arbitration, the Circuit Court, the Court of Appeals, all hinging on these subtle but really powerful distinctions between legal doctrines. It's definitely a reminder that even in business disputes that seem straightforward on the surface, the law can take some unexpected turns. And yeah, the wording of your agreements, it matters a lot. The difference between an $80,000 judgment and over $1.2 million literally came down to how these nuanced legal definitions were applied.
Yeah, this case illustrates it beautifully. Knowing things is valuable, sure, but understanding how legal reasoning works and the nuances, that's paramount. It really encourages critical thinking, doesn't it? How precisely are duties defined in your agreements? When do they truly stand apart from the contract itself? And maybe more practically, how well do your contracts anticipate and spell out the consequences for different kinds of breaches, especially things that feel like intentional misconduct?
It certainly makes you think differently about your own agreements, whether you're dealing with physical stuff or these intangible assets, digital licenses, domain names, even vanity phone numbers. The clarity, the specificity of your contracts and really understanding the underlying legal duties, that can be everything. So as you reflect on this deep dive, here's maybe a final provocative thought for you. In our world, which is becoming more and more digital, with so many assets being intangible, how might future legal battles keep challenging these traditional legal frameworks? And maybe more personally, how thoroughly do you understand the specific duties and limitations in your own agreements, especially around digital or intangible property, to protect yourself from these kinds of costly disputes?